Okay, welcome back to Transformation Ground Control Podcast. My name is Eric Kimberling. I'm here with Carissa Noble. Thank you for being here today. And what I wanted to do before we get to our first guest is just to remind you to please subscribe to the YouTube channel, follow Third Stage, and follow myself on LinkedIn, Twitter, Facebook, whatever your social media platform of choice is. You can also subscribe to this podcast in audio formats on Apple Podcasts, Google, Spotify, Pandora, whatever your podcast preference of choice is. And so we publish these weekly podcasts once a week. Every Wednesday morning, U.S. time is when we go live on YouTube with the broadcast. And then we also have distribution to the podcast platform shortly after that. So I encourage you to be sure to subscribe on whatever platform you prefer to watch or listen to us on. So next guest here, our first guest, I should say, is Marcus Harris. He's going to talk about contract negotiations. And contract negotiations is one of those things when, especially if you're buying or acquiring new technology for your business, if it's financial or accounting software or enterprise software, human capital software, whatever that may be, CRM, Salesforce, all those sorts of different technologies you might be acquiring for your business, there's a lot of hiccups and gotchas that you want to watch for, and that's what Marcus Harris specializes in. So we thought we'd pick his brain a little bit and ask some questions around best practices and lessons from his experience helping clients negotiate contracts. And in some cases, he also will help when there's a lawsuit involved too. And that's actually how I got to know Marcus. Was I testified as an expert in one of his cases several years ago as an expert witness. And we've continued to work together over the years on multiple cases, and he continues to be a friend of Third Stage Consulting. We work very closely together on a number of engagements through the years. So with all that being said, I want to welcome Marcus to the show. Marcus, thanks for being here today.
Yeah, well, thank you for having me, Eric. It's always a pleasure to talk to you.
Good. So as companies are thinking about their contract negotiations and getting ready for the acquisition of new software and the services that go along with that, there's a lot to think about. A lot of times we hear from clients that their heads are spinning in terms of the number of things they need to think about, or maybe not necessarily understanding the details or the T's and C's of the different contracts they're signing. But from your perspective, since you do this every day, this is what you specialize in terms of negotiating contracts and helping your clients negotiate contracts. If you were to summarize for listeners today, why is effective contract negotiations so important?
Well, I mean, I think the way that I look at it really is it's an opportunity for you to come to some sort of a meeting of the minds with respect to what your expectations are or how that project is going to be going. Who's responsible for what aspect of that project. And it really is part and parcel, in my view, to having an effective contract or not necessarily contract management process put in place, but an effective project management process. So contract management is certainly one thing and one aspect of the contract negotiation in itself. But I think fundamentally, you want to approach the contract negotiation process as a means for being able to manage your relationship with that vendor for really, the duration of the project, and potentially beyond the duration of the project, depending on what kinds of services are going on an ongoing basis. So it really is an opportunity that you need to take advantage of. And I think you've got to look at it from at least two perspectives. One, I think, I'm an attorney, so I'm going to recommend that you look at it from a legal perspective, and it's a contract with terms and conditions. So you're kind of forced to look at it from that perspective. But if that's the only way you're looking at it, I think it really is a missed opportunity because, like I said, fundamentally, it's one of the only chances that you're going to get on the front end to be able to put in place a process for managing your relationship with the vendor. And that's incredibly important.
Right. So along those lines, then, when you're helping your clients through this process and you're either leading the negotiations or advising your clients on how to negotiate with vendors, what are some of the biggest pitfalls or traps that you see your clients walk into, or they have the potential to walk into during the whole process?
Yeah, I think there's really two answers to that question. I think from a client perspective, where I think clients make a huge mistake is really focusing on the amount of the discount that they're going to try to negotiate. So, it's that's certainly an important aspect of the negotiation process. What are you going to get out of this fundamentally, right? I want to get the best deal that I can get, but if you're just focused on the amount of discount you're getting off of list, or the pricing structure of the contract, you're really missing out on an opportunity. And I think what you want to do is use, again, the contract as a tool for putting in place a process for managing your relationship with the vendor. And it takes a variety of flavors. I mean, there's a change management process that you can negotiate. You're also going to want to see if you can put in place, especially in this environment, some kind of dispute resolution process that is short of a litigation process, and maybe even short of arbitration. So that's one area where I think clients make a mistake, is focusing on price to the exclusion of everything else. And I think if that's the way you go about it, you're missing an opportunity to negotiate things in that contract that will impact price much more than any kind of an initial discount that you might be able to negotiate. The other way I look at that question, and a common pitfall, is to some extent it's more of a T's and C's issue. I think if you're focusing primarily on kinds of these kind of abstract legal concepts that are certainly important. Look, getting a warranty and non-infringement, service warranties with respect to performance, those are all key issues that you want to negotiate. But sometimes I think you can negotiate and focus on those to the exclusion of some of the practical things that might matter that are in a contract. And that's where having really experienced counsel that understands, not only the legal terms and conditions, but how these things play out from a practical perspective in real life. One example would be, negotiating a limitation of liability is, like I said, it's important. But, depending on the value of the entire deal, you're going to want to take a different approach to that. And, having, some kind of multiplier of the limitation of liability on something that's a project that's low in dollars, that may or may not make sense. It just depends on how that really is going to play out, what type of functionalities being implemented, and what the risk is, and what the relative position from a negotiation standpoint or a leverage standpoint of the two parties is.
Right. Yeah. And I want to come back to something you mentioned around negotiating, not just with software vendors, but there's also more the services side. You talked about change management, things like that. So I want to come back to that in a second. I have a follow-up question for you there. But I guess just sticking with the software vendor side of things, if we think about this as sort of a two-pronged negotiation approach, typically where you're negotiating the software and then you're negotiating the services to go with it. When we think about the trend towards cloud and more subscription-based pricing and subscription-based models, what are some of the nuances to watch for there? How is that different than negotiating what we might have negotiated in the past with our on-premise sorts of contracts?
Yeah, I mean, I think there's two things that jump to the forefront, really, when you're talking about the difference between on-premise contracts and subscription-based contracts. And I think fundamentally, when you're getting into a subscription-based contract, you're going to want to understand the process by which you can get out of that contract, okay? Because the vendor's goal is a little bit different. They want to have automatic renewals. They want to have automatic price increases. And your goal as a customer is really to have the most flexibility that you can, but you also have to understand that to the extent that you're getting into that kind of a deal, a subscription-based deal, the discount is going to be to some extent directly tied to how long that deal is. So the vendor wants to sign you up for as long as it can, with as little flexibility as they can give you, whereas you have the opposite goal, and you want to have short time commitments with maximum flexibility to get out and adopt a new system and replace that system. So that's one thing. And I think one of the other things that comes to mind, really, it's all about data, right? In an on-premise solution, it's a perpetual license that to software that's going to be primarily located on site on servers, in your building. And just to a large extent, I mean, your IT department is going to be responsible for managing and maintaining that data and accessing, you know, personally identifiable information of your customer base and your employees as well. When it's in the cloud, it's really a whole different environment, and you really want to understand how your data is handled by whatever vendor you're talking about. Is it bundled with other companies' data? What kind of data protections do they have? What about some sort of data breach or data incident? How is that going to be handled, and who's going to be responsible for it? And what kind of limitation of liability is that going to be subject to? Because you want to make sure that if something like that happens with your data, that you've got real remedies under the contract to make you whole. So it's substantively different in certain ways. I mean, fundamentally, I think you're getting a license under both scenarios, but there are different things that you need to focus on to make sure that you've got real remedies that address the problems that are likely to happen in both different types of environments.
Right. Yeah, and in addition to cost, like you mentioned, there's a lot of other things you just talked about as far as non-financial, non-cost related issues to be thinking about or negotiating through. But back to the point of cost, in the difference between cloud and on-premise, we've seen in our experience that a lot of times that there's hidden costs and escalators and things of that nature that even if it's not your number one priority is to contain those costs, those things can sort of sneak up on you. And those are clauses or kickers that weren't necessarily there when you were negotiating your on-premise systems, however many years ago. So what are your thoughts on just purely the cost side of cloud contracts and some of the pitfalls there versus the more traditional on-premise?
Yeah, well, and that's a nuanced issue, and I think it's a good issue to talk about because, for years, I think there's been this kind of mantra of the cloud, and I think it's, most of the contracts that we negotiate today and most of the contracts that we litigate today are certainly subscription-based agreements. They're cloud agreements, and that really is just the way the industry is going. But, the mantra that the cloud is cheaper and that it's less expensive and you don't need as much to get the same system as a big company. I think there's some truth to that, but underlying it all, and you suggest this yourself, is that there are enormous pitfalls with respect to ongoing costs and fees and escalators and that kind of thing. And you really have to understand what you're getting yourself into, and to make sure that you negotiate proper discounts, that you're not unnecessarily locked in. There aren't just the vendor isn't at his discretion with respect to the kinds of price increases that can happen year over year. You've got to make sure that you've got the right caps in place, that you can manage that contract appropriately. Because once you're in it, it's really hard to get out of. And I don't think that people think about that necessarily. I mean, when you're running your entire business on a cloud-based product, just switching it, in a matter of months is not necessarily something that you can do. And the vendors know that. And, their goal in a very real way is to lock you in and to, charge you money for their services, and to some extent extract fees from you on an ongoing basis. And that has kind of a negative connotation. I think that's really what these salespeople try to do. It's get you on their system, make it hard for you to get out, and bill you as much as they can. And you've got to be aware of that on the front end, that's going to happen.
Yeah, it's almost creating higher barriers to entry or making the switching costs higher for you in this new world of cloud contracts.
Yeah, no, that's absolutely true. And I think what goes hand in hand with that, it's not from everything relates back to cost fundamentally, but what you have to make sure you account for, not in addition to just cost increases in general and discounts and putting some kind of control or cap on a vendor's ability to do that, is how do you get your data out of that system, right? I mean, what kind of obligation will that vendor have with respect to pulling your data out and giving it back to you? Because what you don't want is to walk right into a situation where your data is held hostage. And, I'm not saying that that's the intent of any kind of vendor, but a lot of times the contract language doesn't obligate them to do anything with it. And sometimes, there's a fee for transferring your data or for having some kind of a transitional use right or transitional services to another. And that you've got to make sure that you go in with open eyes and that you're able to mitigate any kind of cost associated with that. Because for me, there's two competing interests in either type of agreement, whether it's a on-premise document or if it's a subscription agreement. And the vendor's goal in every one of these agreements is to put as many restrictions on you as possible with respect to your use of that functionality, and to capture additional revenue streams on an ongoing basis, right? So it's here's the usage metric, here's the user count, here's what this type of functionality does. If you want to add different types of functionality, there's going to be a cost for it, and that's fine. That's just the way it is, and that's to be expected. But the user's competing interest, I think, very much is to have as much flexibility as possible. So the goal really is, to the extent you can get there, is to have as much indicia of ownership over that functionality, that technology, software, as you possibly can have in the context of the license or the subscription. So it's about having flexibility to run your business the way that you want to run your business without having to be constrained by the vendor's fences around your relationship with that piece of technology, or to the extent that you need to at least know what those fences are and what the fee is. So if you know that, then I think you're well ahead of the game.
Right. No, that's great advice. But one thing I wanted to do is shift gears a little bit and talk more specifically around system integrators or VARs, resellers, implementers, whatever you want to call them, basically the implementing partner that's going to help you implement the technology. And you alluded a little bit to this earlier in the conversation, but when we think about negotiating with system integrators or the implementers, what are some of the nuances of negotiating with them, some of the things to be watching for?
Yeah, well, I think really it's a whole different game, right? Because when you're negotiating with a software vendor, the negotiation points are fundamentally different. And I think what you've got to realize on the technology side, and there's some qualifications to this, but look, generally, if you're using a first, second, even third tier software provider, the technology works, okay, and it absent some issues associated with being oversold or misrepresenting certain types of functionality, that's not usually why these things fail, these implementations. Okay, it's very rarely, and I don't think I've ever seen it be a purely technical issue where the software or piece of functionality just didn't work. It's usually one of two things. One, it's a fraudulent inducement or negligent misrepresentation scenario, and those are just fancy legal words for software being oversold by an overzealous sales team. Okay, they're either entering that vertical for the first time and they really want to get in there. They don't really know what the gaps in functionality are, so they oversell it or they minimize them. And you buy that software and then it doesn't work the way you anticipated it working. That's a fundamentally different issue, though, than I think it just not working, right? But that's one bucket of issues that I think you need to be cognizant of when you're negotiating with your software vendor. But where it's more likely to fail is because of a people issue. And the people issues are fundamentally going to be contained in the integrator or implementer documents. So the master services agreement, the consulting agreement, and the subsequent statements of work associated with the project. And the good thing about it, though, I think if you go in with eyes wide open, then you've got a real opportunity with the negotiation of that contract to put stopgaps in place on the front end that are going to minimize the likelihood that your implementation results in a failure. So, what are some of those stopgaps that you put in? Well, you want to have the ability to manage the types of consultants that you're going to get. You want to make sure that they're primarily focused on your implementation. There's a whole bunch of legal ways to do this, but what we see regularly, and it doesn't always result in failure, but we see, you get promised essentially the A team, okay, and then you end up with the D team, and it's sometimes because a bigger customer comes along that sucks up all the resources, and it's a more profitable project for the implementer. And so now you're left with kind of, the bench that really isn't as good as what you thought you were going to get. And so now you take a second place to this other customer. That happens on a pretty regular basis. But, the good thing is, though, you can put in language in the contract that minimizes the likelihood that it's going to happen. And to the extent it does happen, then you got a process for dealing with it. So it's those types of things that you want to think about on the front end so that you don't have to deal with them on the back end. And make no mistake about it, when I say back end, I mean through a lawsuit or litigation or through a failure. So if you can do as much as you can on the front end with these implementation agreements, these consulting agreements, integration agreements to manage that team, then you're really putting yourself in a successful position, and you're minimizing the likelihood that you're going to have a failure. So I think that's one of the biggest things to watch out for, and it's not a technology issue; it's a people issue.
Right. Now, do you notice a difference between negotiating with some of the larger system integrators and implementers versus the smaller, more boutique ones? Are there different types of issues you worry about? I'm sure there's a lot of commonalities, but are there differences or things you worry about one over the other, or any difference there?
Yeah, I mean, there are, and I think when you're dealing with a smaller firm, you really want to make sure that you've got language in there that really minimizes the likelihood that they're going to have resource issues with their consultant. You want to make sure that they are assigning the people that you expect to be assigned to that project, and they're going to be there from the beginning to the very end, to the extent you can do that. And there are issues with that is to minimize or to come to an agreement with somebody like that. And I think generally, though, those types of companies are less sophisticated. The agreements are worse. They take longer to negotiate. When you're dealing with the Accentures or the Capgeminis of the world, you're dealing with a much different type of animal. But fundamentally, the issues are the same. But you've got to deal with it and come at it from a different type of perspective. You're usually going to have within the four corners of their contract and their SOWs, and you're going to have to be suggesting language to them. They may already have their built-in ways for dealing with things, and you're going to have to adapt to using their clauses, their provisions, and working with that to make it work for you. Because remember, all these companies that you're going to deal with, they're going to give you concessions, but the language that they're couched in, that language is going to be incredibly unreasonable. It's going to be one-sided, so you're going to have to modify it to make sure that it addresses what your concerns are, while at the same time addressing their concerns. And I think the biggest risk you've got with one of these large scale implementers, the Capgeminis or the Accentures of the world, is that they use your project in one of two ways, right? They see it essentially as a cash cow that doesn't have an end, that doesn't they don't have much regard for an agreed upon scope. They'll put language in the statements of work that minimize your ability to manage the scope or manage the project. And you've got to watch out for that. The other thing that they sometimes do is they use your project as a training ground for unqualified or incompetent even consultants. And you've got to manage for that as well. And there's actually a term that I learned from you. You don't want to get eccentric, right? And that's something that I think they can pump the billable hour through a project, and you've got to minimize their ability to do that and make sure that you have the contract tools in place to manage that scope. Because if you don't, you're going to spend an incredible amount of money. Whatever scope estimate or budget estimate they gave you in the beginning, you're going to blow through that quickly, and you're going to be many months into your project or years into your project. You're not going to be anything, and that happens all the time, frankly. And we have clients that come to us and say, "What do I do now?"
Yeah. And I look back in my career and look at how I started, and that's how I started. I worked for a big system integrator that taught me about consulting, but I learned about it on clients' dimes, and there was a lot of people there like me that were, just off the school bus, so to speak, just out of grad school or out of business school, and you're learning on the client's dime. So I think that's a really good advice, and and also it gets back to transparency and also control of the project. Who actually controls the project and owns the project? Do you own it, or does the system integrator and VAR own it? I don't know if you run into that issue. I know at a later date, we're going to talk about failures and lawsuits. But without going too far down that path, I mean, what are some of the the nuances there, or some of the challenges you've seen?
Well, that's standard, integrator language. You look at an SOW, and the assumption section of that SOW become incredibly important. What happens is that they say that they're working for you at your direction, and they essentially try to wash their hand of the project as much as they can from a management standpoint, that they're going to take their direction from you. But the problem with that is, the life cycle of one of these systems is, I don't know, 15 years, 20 years. So the likelihood that, anyone in your organization has substantive project management experience that's recent is probably minimal. You're not going to understand how to manage that project, and they're going to take advantage of you. They do it all the time. And so, the key is, again, putting in milestones, deliverables, deadlines, dates, a rigorous change management process that holds them to account. Because if you do that, then I think you minimize the likelihood that you're going to get accentured, so to speak, right? And I think it's imperative upon you as a customer really to make sure that you're bringing in outside consultants, or to the extent you've got in-house experience, rely on that. But you're just going to be outmatched if you don't have people on your team managing your project, both from just a day-to-day management perspective and really from a change management perspective too. I think that becomes important this day and age to get the right kinds of consultants on board, because if you don't, I think you increase the likelihood of a failure, and the cost that you're going to expend on these types of consultants, it's going to be minimal when you compare it to having to go through right setting a project, potentially getting lawyers involved, and abandoning whatever functionality or software that you were trying to implement and starting all over. And unfortunately, we see that pretty regularly. And I'll nip that in the bud, with some planning and proper resource allocation on the front end.
Yeah, absolutely. Yeah, and I think that that it's such an interesting dynamic with some of the system integrators, or at least especially the larger ones, I should say, whether it's Accenture, Deloitte, or without naming too many names, just any bigger system integrator. Is on one hand, it's like they want to have control and they want you just to trust them, trust the process, trust the way we've staffed this. But as we'll talk about in a future interview, and I've heard you and I have talked a lot about this, is when it comes time for a failure or there's a lawsuit, then it turns into finger pointing. So even though I wanted to control the project and bill you as much as I could and get you just to trust me and trust the process, now that there's a problem, I'm going to point the finger back at you and say, well, it's your fault, or you Mr. or Mrs. Client didn't do what you said you should have done, or didn't do what it said in the contract. So that's a pretty interesting dynamic, how it kind of cuts both ways in many ways.
Yeah, well, I mean, it is, and that's kind of the bread and butter of the integrator side. Is to give themselves the flexibility to be able to point the finger back at you, but in the project management, have enough control to be able to assign the resources they want, to work on it the way they want to some extent protect their revenue stream. And I mean, I feel like we're beating up on them and being a little bit negative, but again, we see this. Not every day, but certainly, I mean, it's a major component of my practice. And, how these guys operate, and they give themselves the flexibility to be able to have it both ways. And, if you're going in with your eyes closed, it's like a lamb to the slaughter to some extent, and you're not going to come out of that unscathed. They're definitely going to point the finger at you. They're going to have the tools in that contract process to be able to do it. So,
yeah. Well, it's always interesting to me too how all the stuff you're talking about so far is so important, but yet when we look at organizations and where they focus their time and effort, they spend so much time and effort on trying to figure out what technology do I want, and make sure they're finding the right fit, that's an important step in the process. But then it comes time to review the contract, and usually it's a CIO or an IT director or a CFO maybe who just kind of passes it on to legal counsel, their internal legal counsel, who's never reviewed an ERP or software or contract in their lives potentially, but they're the ones that are providing more of the legal input. But a lot of what you're talking about isn't just legal stuff. It's more strategic, how you're going to run the project, how you're going to own it, all that sort of stuff.
Yeah. And it goes beyond just the pure T's and C's, you know what I mean? And I think, to be quite honest with you, I think any competent lawyer that negotiates commercial transactions is going to have an understanding of limitations of liability, warranty obligations, indemnities, those types of things are relatively standard. There's nuances, without a doubt, in this world that are applicable, and not every commercial transactions attorney is going to understand them. But what I think you get when you have experienced counsel that has been doing these types of deals for a very long time is you get that kind of perspective, right? You want somebody that understands, how they fail, because if you've got somebody that's negotiating in a vacuum, from a theoretical standpoint, that's not really going to serve you very well. You've got to have somebody that can balance those types of things. My biggest issue with clients, and this happens a lot. Not only do they review them without the competency to review them, when they give them to us, many times they say, "We'll take a light touch on this. We don't really want to spend a lot of money on this. Just focus on the big things." And that's incredibly challenging to do, and to some extent, I think it's short-sighted, because if you're spending millions of dollars on a software project, and you don't have the right budget to review the contract, which is the one tool that you can really use to manage that project and mitigate against a failure, you're not really looking at this in the right way, from my perspective. I think
Yeah.
you're almost shooting yourself in the foot.
Yeah, and you're talking about such big risk, high ticket, high dollar types of issues that if you gloss over this, I mean, you're gonna be paying for it both financially and risk mitigation wise for a long time.
Yeah, and I think the financial aspect of it, it's not just what's right in front of you either, right? I mean, it's not just the money that you're out that you paid. It's about let's say you go through a failure, and you've got a large consulting firm, and you've got one of the top ERP vendors or whatever software it is you're integrating or implementing, and it fails, and it's the backbone of your business. It's not just the fees that you're out, but it's conceptually, where would you have been had that software worked financially? If this thing took you a year and a half to figure out it didn't work, or longer, think about all the resource allocation and the profit that you didn't get to realize because you're not where you thought you were going to be. And and it's not just that. So it's the money that you're out, it's where you would be today, and then it's the cost of what we call cover, right? It's replacing that software and that integrator with somebody that's competent. So now you've got to do it all again. And I don't know what the average implementation time is. It depends on what you're implementing, I suppose. But let's just say it's a year and a half or 2 years for some huge project. Now you're 4 years away from where you were. And we've talked about these things before. You've got like the little example comes to mind where it took years to implement this software. It failed because of some nuanced issue that they should have known about beforehand. And at the end of the day, they went back to their legacy their legacy system. Where would they be today had the software done what they thought it was going to do?
Right. Yeah, absolutely. So this is a lot of good stuff to think about. And as our audience who may be about to sign on the dotted line for a contract or an implementation of technology, what are those 2 or 3 closing things that you would summarize? Here are the things you should be thinking about or looking for or doing as you continue down that path.
Yeah, I think what I would emphasize is don't just focus on price, okay? Because if you're focusing just on the cost of the software on the front end, you're really doing yourself a disservice, and you're missing opportunities to manage the overall cost of that system for the life cycle of that product, for the life cycle of the license, for the subscription that you're going to have. So you want to think about just not just the money you're spending today, but put in place caps, flexibility provisions that allow you to suspend portions of the license to trade out pieces of functionality. That's how you need to be thinking. You've got to be thinking from not just the initial cash outlay, but a flexibility over the long term. And what flexibility equates to is cost savings. That, I think, is really on the software side. Okay. On the integration side, I think it's really all about project management. You've got to make sure certainly that you've got the reps and warranties that you need on the front end, that these services are going to be provided in accordance with generally accepted industry standards or whatever the metric is, right? It's always, these warranties are always a warranty of reference, so it's to something, some sort of specification, and it's a warranty of time. It's a period of time, how long that warranty is going to last. That's all important stuff. But I mean, I think more important to some extent is that you're focusing on the aspects of the deal where the project is likely to fail. And you're putting your fingers in the dike, that anticipating it, and you're mitigating the likelihood that that's going to happen. That to me just makes the most sense. And I think, it's not just in the base consulting agreement, but it's in the SOWs, it's in, collateral documents that you might see, project status reports. How are those going to be handled? What are they going to say? How often are they provided? Prints, specifications, all of that stuff becomes incredibly important. It all ties together. And if you're not thinking that way, you're going to be in for a process, and it's not going to be a fun process.
Yeah. As difficult as attorneys are to deal with, no offense, it's a lot easier to deal with them early on than having to deal with someone like you later on when there's a failure or some sort of contract dispute.
Well, absolutely. I mean, there's a saying in my business that early legal advice is not expensive. Okay, it's legal advice that you get on the back end. That's when it becomes incredibly expensive. And when we talk about litigation and when these things fail, I mean, maybe we'll talk about some of the pricing, the cost of litigation, and how much these legal fees actually cost. Because once you know that, the contract negotiation process, the legal fees that you spend on that's a bargain, to be quite honest with you.
Right. Yeah. It's always cheaper to get it right the first time.
Exactly.
Well, good. Well, I appreciate all the feedback and the great discussion here. How does our audience get a hold of you if they want to learn more about you? What's your website address, or what's the best way to find you?
Yeah, absolutely. I think the easiest way to find me is really, taftlaw.com is my URL, and you can just plug my name in there, Marcus Harris, in the attorney directory, or just search Marcus Harris software. A bunch of things are going to come up, from blog posts to YouTube videos to things like this. So easy to find. It's just Taft Law, Marcus Harris Software Attorney. Those are the best ways, and you can go from there. Check out some of the things I've published, some of the things I've said, and decide if you want us to help you out over here at Taft Law.
Okay, great. And we'll include a link to your email address in the information field below for those listening that are interested in reaching out to you. So thank you very much for joining us here today, Marcus. We appreciate you being on the show today.
Yeah, absolutely. It's always a pleasure. Thanks.
All right. Thanks, Marcus.
La, la.